Well, hello and welcome once again to the Disability Law Show. Good to have you along, hopefully for the entire half hour. John Scholes here, Tamar, Agopian there, disability lawyer at disabilityrights.ca. Of course, always reaching out to Tamar is a good plan. If you have any questions while we're doing the show afterwards, that's cool. The number, of course, toll free. Consultations are free. I'll throw that in there as well. 1-855-821-5900. Back it up with an email. How about that? help@disabilityrights.ca. We'll give those out throughout the show if you miss them for sure. No problem. Chronic pain and LTD denials. That is the main topic a little later on in the show, so we'll get to that. Some phone calls, emails. It is always really, really busy tomorrow, but we always start off with something you want to bring to the table, like a case of the day sort of thing. What do you got today, pal?
I've got a couple of things that I wanted to start off with. Cool. And the first is really a shout out to our viewers. Thank you, viewers. I've had a number of phone calls from people who have reached out to me and to other members of our team as soon as they see this show, John, which isn't surprising. And to me, it's, we're supposed to start off these shows talking about a success story. And to me, it's always a success when we're reaching viewers, when we're reaching people to give information about how to deal with their disability claims. Keep them coming, folks. Please continue to call us. Our consultations are, of course, free. We have lots of different resources, which we're going to talk about throughout the show. But the starting point is always you and trying to answer the questions that you have about your disability claim. And we do see common themes over and over, and we will talk about some of them today, including chronic pain and other things I want to get to. But we would not be where we are without all of you. And so a shout out to our fine viewers and mom and dad who I know who are watching. And then with that, a close second. So the other thing I've been working on this week, John, a bit of a theme, I suppose. I managed to resolve two claims that have very similar facts that I wanted to highlight with our show. And so this fact pattern we see because it's very easy for the employer's disability plan to point the finger to the disability insurer and the disability insurer to point the finger to the employer. What do I mean by that? Most of the disability plans that we talk about on our shows and radio and what have you deal with individuals who have group disability through their employment. And so you're employed, yourself and all of your coworkers are insured under these plans that include short-term and long-term disability benefits. And invariably, as you go through the process, depending on the type of claim that you have, there is interaction between your employer and the insurance company as they evaluate, review your claim, and review whether or not they're going to continue to either approve or deny your disability claim. So I've had two clients come to us with a very similar situation where they had to go off work due to mental health conditions, primarily depression and anxiety. It's not that the both situations are exactly the same. And I want our viewers to know that mental health has very specific requirements, very different complexion from person to person, which is why we see a lot of resistance from insurance companies when they're evaluating these claims. Adjusters have the tendency to do sort of a one-size-fits-all, and in that creates landmines where they're making hasty decisions to cut off claims on improper bases. And one of the reasons we see a lot is when the backdrop of the mental health conditions is tied to the employment situation. And so in both of these instances with my clients, they had a poor work situation with compounding mental health conditions, so things that were getting worse over time. And it got to a point where their doctors recommended, both happened to be gentlemen working in sort of office-based type work, and both of them had to go off work. And so the employer then gives them the forms, they apply for short-term and then eventually long-term, and then of course get denied. And in that time, they make an attempt to return to work. For one of my clients, that attempted return to work came after we became involved. The other client, it was actually before we became involved. And why do I mention this is because of what I was saying earlier, where there's interaction between the employer and the disability insurer. In the instance where, in one of my client's situations, they attempted to return back to work, the employer resisted their return, didn't want to have them back, and said you should go back onto disability. And disability insurer said no. You don't have a proper claim for recurrence or a disability claim. In the other instance, there was an attempted return to work, they went back to work, and they got terminated. And so This is why we're so well suited. I say this time and again, that we deal with employment matters and disability matters, myself in particular. And I don't want anyone to feel as though this is a barrier for moving forward. These claims are excellent claims that we can deal with both the disability insurer and the employer, and we've done so successfully. And so in both of these instances, we were able to get a settlement, and we got settlements that were well beyond what I think would be the norm, because both the employer and the insurer got it completely wrong. They were pointing fingers at each other. One was saying, oh, it's an employment issue, not disability. Employer was saying, nope, this is not an employment issue, it's a disability issue. And what ends up happening is these poor individuals get caught in the middle. And so they get caught in the middle, John, and then they don't know where to turn, right? They feel that pressure of having to return back to work. And if that return to work isn't going to be successful, then what's the answer at that point when they're getting resistance from both sides? And I think the key, really, the main takeaway here is that there is potentially a viable claim, both on the employment side and the disability side. And so you want lawyers who are capable of doing that analysis, looking at your medical information, working with your medical team to get the right information over to support either the disability claim or potentially a duty to accommodate or a failure to accommodate kind of situation as it relates to the employer. Either way, great success for both of my clients. I give them a lot of credit because the attempt to return to work is also a bit of a challenge, and you kind of want to deal with that carefully. And in the end, they retained us, and we were able to get good results for both of them.
If they return to work and they fail, is there a problem getting back on claim?
There was, yes, especially for one of my clients. But we see this not just about my client's situation, but we see this more broadly. Look, there are recurrence provisions in these disability plans. It's a provision that says, or a section in these policies, that says if your health issues continue to prevent you from working or recur again or are so harsh or difficult to manage that your doctor pulls you off work, then the policy is expected to respond to allow you to access further disability benefits. That's the intent of the policy. Different policies have different words in them, but generally speaking, it's meant to motivate people or incentivize people to actually attempt to return back to work. And so why does it mean that insurance companies resist these claims? Well, because it's too easy, John, for insurers to say, you can be better accommodated by your employer. And that's the barrier and not your health issues. Therefore, we don't really want you back onto our policy because then we have to end up having to pay you. So I think this is why return to work processes can be really, really challenging. You want to make sure you've got good support from your practitioners before you make that attempt. You want to make sure that you're going to be successful. But ultimately, if you're not, or if that attempt is being held against you by your insurance company, your disability insurer, it doesn't mean that your claim stops there. It doesn't mean that you're not entitled to disability benefits. And in fact, the nature of the job that you return back to, maybe you're not earning full earnings. That could potentially mean you have another claim against the disability insurer. I mean, I could probably do a whole show about this.
For sure.
But I wanted to just start off talking about it because of that interplay and the importance of people exercising their legal rights in those situations.
Did you say these were both mental health issues?
Yes.
Okay, so are insurance companies more likely to deny off the hop with a mental health condition rather than a broken bone or cancer or something like that?
I think so. I think we're still seeing that, especially if there's some kind of underlying work consideration, which there was in these two instances, where you've got a difficult work situation or a difficult supervisor or some conflict with your coworker, or just simply your work duties are too overwhelming for you to continue to keep working. And so then it becomes that much more important what your doctors are documenting around the nature of your condition. Is it that your employment triggered your health issue? Or is it that your employment is the only reason why you can't work and you could do your job, say, in another work setting? And these are the key questions we have to ask people when they contact us. But they have to contact us. That's what I'm getting at, is that there's this, misassumption, this myth, I suppose, that, oh, well, I attempted to return to work and, my company's not letting me back, or my insurance company's saying no, and it must mean it's the end of the line for me, which it absolutely is not.
Another thing we also focus on every show, Tamar, is pocketdisabilitylawyer.ca. This is kind of another avenue, a quick way to find out if you should carry forward with your case. Tell me about it.
Absolutely. And so these are the kinds of tools that I think are fantastic. And this is, again, something that was born out of the Pocket Employment Lawyer. And so it's a very, very easy tool. It's a drop-down menu, anonymous, we're none the wiser, but at least it's a starting point for people to make that inquiry. And they can go in there and actually get some basic information on, should I be speaking to a lawyer? If you want to, great, then there's information there. But if you don't, you shut down your browser, we're none the wiser, and at least then you've got a little bit of information to go off of as you're making decisions around what to do with your claim.
Again, pocketdisabilitylawyer.ca is the way you do that. Phone calls come from our radio shows across the country. Want to find a station near you? Just go to disabilityrights.ca. You'll find a station, tune in, and hopefully call in, right? And your voice may appear on air at a different time like this one. We'll get to our first phone call of the show tomorrow, so listen up.
I'm a single parent dealing with depression and PTSD after a bad car accident. I've been on long-term disability since then, going to therapy regularly and taking medication. Now, I just got a letter from my insurance company saying I'm at the return to work stage and they're cutting off my benefits soon. Honestly, I don't see how that's possible. My therapist says I'm not ready. Can they really force me back to work?
How many times have we heard this before, right?
So often, John, and it's actually really deflating to keep hearing people, and you can hear the frustration in her voice,
Absolutely,
right?
yeah.
Is this possible? Unfortunately, it is possible. Absolutely. Insurance companies continue to pressure people to return back to work. And no, it's not correct. It's not right, but it continues to be done because it's a tactic, right? And I think what's even worse is that when you've got your own practitioners supporting that you've got a verifiable disability, clearly in this instance as a result of a motor vehicle accident, then you need the time for that recovery. You need the time, quite frankly, when you've got post-traumatic stress disorder like this caller does, that recovery is prolonged. And insurance companies don't actually want you on claim for that whole time that it may be required to have you feel better and do better. And so it's not surprising that in an instance like this, they're trying to get her back to work. And I think that there's a few factors also that are at play. The number one thing that I always suggest to people in situations like this is do absolutely get clear advice from your own doctor about what to do. And it could be your doctor, it could be a therapist, it could be a combination of the two, especially with PTSD. It can be a multifactorial way of treating these kind of conditions, so different means of treating PTSD. Get all of those individuals that you're seeing to send over updated reports to do the kind of medical information, detailed information, that will support that a return to work is not something that should be on the horizon and is medically not recommended. But also when you're dealing with motor vehicle claims, it's important to keep in mind that you want to make sure that you're exercising all of your legal rights. So when you've been involved in a motor vehicle accident, it's not just that you could access short-term and long-term disability benefits. Particularly in Ontario and really across the country, different provinces have different regimes, but there are benefits that you can access from your own insurer and potentially the at-fault driver's insurance company for health care, for income replacement, and if you weren't at fault at the accident, you could also potentially have a legal claim against the at-fault driver. So we call that a tort claim. We call, SABs in Ontario and other things in other provinces. But generally speaking, what you want is a law firm that has expertise in all of these areas, and that is our team. So we've got multiple members, including myself, who have dealt with motor vehicle litigation in the past. And when you're dealing with the disability insurer and potentially other insurance companies in these different claims, it can be very overwhelming. So John, the key takeaway here is, what does the medical information say about whether or not this person is ready to return to work? If there is no clearance for a return, then in my mind, that is the end of the conversation. And that is what she should be pointing to say, thank you, adjuster, but my doctor or my therapist has said I'm not ready. I will not be returning back to work. Now look, it's easy for me to say this because it could mean that they're preparing to cut off her claim. But if they're preparing to cut off her claim prematurely, then she absolutely has a basis for a legal claim, and we could help in a situation like that.
And with that, we'll get into a very short break, and upon our return, chronic pain and LTD denials, what you must know. And as we get into that break, I'll give you the contact information to reach Tamar and her team, 1-855-821-5900, help@disabilityrights.ca. Lots more of the Disability Law Show is coming right up. Stay with us. People think contractors aren't owed severance. EmploymentLawyer.ca says that is a myth. Many contractors are actually employees and are entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca. How do you force insurance companies to pay long-term disability claims?
Insurance companies deny legitimate claims all the time. They're playing the odds. They know that most people are just going to walk away.
Your insurer may ignore you, they may even ignore your doctors, but they can't ignore us.
We know how insurance companies work. We know their weaknesses. We know how to use the legal process to force them to pay you what you're owed.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you are only owed 2 weeks' pay when you lose your job. EmploymentLawyer.ca says that is a myth. You may be owed much more than 2 weeks per year. Don't settle for less. Always check with the employment lawyer first at EmploymentLawyer.ca. All right, welcome back. Disability Law Show. Reach out to Tamar anytime, disabilityrights.ca. Phone number 1-855-821-5900. Help at disabilityrights.ca if you want to back it up with an email. Main topic time for this week, it is chronic pain and LTD denials, what you must know. Number one, Tamar, insurers often deny LTD claims for chronic pain, saying there's insufficient medical evidence. Keep hearing that over and over again. What does that mean?
Absolutely. What does that mean? It means that we don't think there's enough there to support that medically that you cannot work. But it's a favorite line of insurance companies and adjusters, and I see this insufficient medical information phrase. I was going to say garbage phrase. Maybe I should say garbage phrase. This phrase, I see this a lot consistently in denial letters. And so, look, a couple of things that I want to say about chronic pain right off the top. Chronic pain has been recognized by the Canadian Human Rights Act as a disability. Okay, we should start with that premise that there's nothing insufficient about it, I suppose, on its face. And so, yes, it can take some time to be properly diagnosed. There can be lots of medical issues that go with this idea of chronic pain. Lots of symptoms, physical, mental health, fatigue, headaches. I've seen all sorts of things with chronic pain. And so it's unfortunately a difficult journey for most people. And the nature of chronic pain is that it doesn't get better with time. And it can have a lot of treatment measures. It needs to be looked at in different ways depending on how your chronic pain is, how you're feeling about it, where you experience it, how did it come about. And so it's not surprising that you're going to get this kind of language from the insurance company saying, not enough. You're not proving to us that you're sick enough. And that is a real problem, at least in the eyes of the law, because in fact, chronic pain, as I said, is a recognized disability. And in the context of short-term and long-term disability, Canadian courts have said, if your function is being impacted, if you're not capable of doing your day-to-day activities because of this pain, that's enough. You are then entitled to disability benefits. And insurance companies know this, I think. Look, their adjusters are not very sophisticated, but they know enough to know that if it's not going to get better with time, let's stop this out of the gates. Let's suggest to a claimant that they don't have enough proof or they haven't shown us enough medically that they are sick enough not to work. And this way, maybe this will force them back to work, or they'll find alternative measures and they may not pursue their legal rights because we've told them they just don't have enough there.
Chronic pain, LTD denials, what you must know. Number two is this. Okay, you don't need objective, keyword being objective, medical evidence to get LTD benefits, right?
Again, another term that I still see in denial letters. And look, their law teams know the cases. They know that this wording around objective is not the test. That's not what you're actually meant to be looking for and looking at. And so let's explain this a little bit differently. Objective means that there is something measurable, technically. If you look it up online, if you do your fair Google, AI will tell you the meaning of objective. And then you look at the opposite of objective, which is subjective. And unfortunately, with chronic pain and the nature of a condition like this, it is largely subjectively reported. It's very hard to measure how I feel pain versus how our viewer may feel pain or someone who has disability feels pain. And it's hard to measure some of the symptoms that go along with it, as I was saying. And so when you don't have measures like this where maybe you can be sent to an X-ray to confirm that you've got this broken wrist or what have you, then you hear this kind of thing from insurance companies where we need metrics, we need something we can sink our teeth into to justify that you're actually experiencing this pain. But that is not the test. That's not actually how you evaluate a chronic pain case. The way that the insurance companies are meant to look at it is your function impacted enough that you cannot work? Is there medical support for what you are experiencing? If so, then that is, again, the end of the conversation. You should be entitled to ongoing disability benefits.
That's about it. Point number 3 is this, Tamar. If your claim is denied or cut off, you have the right to challenge their decision.
So look, yes, I want to say yes right off the top. And I want to say a couple of things around this. This is a great basis for us to challenge disability insurers on chronic pain cases because there have been some case law in Canada, which is rare for disability, but there have been some cases on chronic pain that we can often cite and lean on. And the insurance company, when we sue them, they will send the legal claim to one of their lawyers in their in-house legal departments. We know all of them. We've dealt with all of them. We will frequently refer back to these cases in claims like this and say, look, our client has a very similar case and they were successful in court. So surely you're not going to come before a judge and make the same argument that was a loser for this other insurance company or this other insurance company. So that's the first comment I want to make. The other, more to the point, if you're watching this show, perhaps yourself or a family member, somebody you know who's struggling with chronic pain and is having challenges with their disability insurer, please, please get them to give us a call. Let's have a consultation. And if that's too daunting and you don't want to talk to a lawyer, we actually have a very good comprehensive guide on chronic pain for 2025, fresh off the presses, on our website. So if you want to just get some general information on chronic pain, please go on our website, stlawyers.ca, and take a look. There's so much there, John, and I could probably talk the whole show about chronic pain. But the bottom line is that insurance companies keep using the same words and the same phrases, which really are excuses, to deter people from actually exercising their rights for these benefits. They deny these claims, and you'd be amazed the small number of people who actually exercise their legal rights to challenge the insurance company for these claims. And they should, because they are entitled to benefits. If their practitioners are saying they can't work, their function is impacted, and treatment isn't helping, and this isn't going in the right direction, that's the nature of chronic. That's what that means. And so if it's not going to get better with time, then you've got these policies that potentially pay you until you're 65 years old. That support should be there for you as you're trying to manage your health. And you shouldn't be on the insurance company's timelines, and you shouldn't have to feel like you need to prove to them all of the time, yep, no, I'm still disabled, yep, no, I'm still disabled. And so we're happy to help in these instances.
All right, quick break, phone call, email coming up on the other side. In the meantime, reaching Tamar, simple, phone number 1-855-821-5900, and email help@disabilityrights.ca as well. We're coming back with more. Don't go anywhere.
People think you have to sign back a severance offer by a deadline. EmploymentLawyer.ca says that is a myth. Deadlines are used as a pressure tactic. Make sure the offer is fair before you sign. Always check with the employment lawyer first at EmploymentLawyer.ca. Deny long-term disability claims for mental illness?
When you're suffering from a mental health disability, insurance companies just don't understand. But we do.
They can absolutely not force you back to work. If your doctors say you are not ready and you know you're not ready, they cannot make you go back to work.
If you have a mental health disability and your claim is denied, don't give up. Give us a call and let us fight for you.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you aren't owed severance pay if you are fired for a reason. EmploymentLawyer.ca says that is a myth. Most for-cause terminations are false, and you are still owed full severance. Always check with the employment lawyer first at EmploymentLawyer.ca.
All right, welcome back. A few minutes ago here on the Disability Law Show. As always, disabilityrights.ca to find a radio station that carries our show. Tamar, myself, and James and Savannah, we all get in there and do the show. We invite you to call in each week as well. Sometimes we play the calls back, and they're informative and educational. Call number 2 for this half hour is coming up right now. Have a listen.
My wife's been on LTD for almost 2 years now, but her benefits are supposed to end soon. Her insurer sent her a letter telling her to apply for CPP disability. The thing is, so she's not sure what to do. What if her CPPD application doesn't get approved? Can she resume LTD benefits? She's definitely still not able to go back to work.
Supposed to end soon. We'll stop there.
I know. That's what I actually bumped on right away, is this idea that his wife's benefits are supposed to end soon after 2 years.
2 years out of it, that's all I can milk.
Absolutely not. Yeah. Absolutely not. So look, let's start there. These disability plans have 2 tests to qualify for disability benefits. The first part of most policies say you're entitled to disability benefits if you're totally disabled from doing the occupation that you were doing at the time that you became entitled to disability benefits. And then after 2 years, that test changes. It arguably becomes tougher to meet. And it says, can you do anything else in the world? Anything that you can have the capacity to do with your health that would align with your education, training, and experience. But in communicating this to claimants, people seem to still think that all they have benefits for is 2 years. Well, no. Most policies will pay you until you're 65 years old. This is what I was saying in the prior segment. And so you're absolutely leaving money on the table if you're accepting the insurance company saying to you, your benefits are ending at the 2-year mark, you should go get government-supported benefits instead, which is what this caller is telling us. You can get both, folks. You can get both government-supported disability benefits, in this case CPP disability, which I'll talk about in a moment. But more importantly, your long-term disability benefits don't end at the 2-year mark if the doctor is still supporting that you're totally disabled. And that's the key, is that in this instant, he describes for us that his wife's doctors are supportive of the disability claim. And surely if they're supportive of potentially the CPP application, then in my mind, if the insurance company cuts off at the 2-year mark, hopefully the very next call is to us. But let's talk about CPP disability. CPP disability is a government-sponsored disability plan that offers a monthly benefit, I would say on average about $1,100 a month, up to $1,600 a month, for individuals who have a severe and prolonged disability. It's a 2-part test. And that 2-part test is actually quite compelling. The words alone, when we say severe and prolonged, it says something to insurance companies when you line that up with the words total disability. Now, none of this means that a person is laid up in bed every single day, but it means that your life is altered so much so that your function is impacted so much so that you cannot work. That's the real test, is the ability to work or not work. And so when someone has this kind of support, as this caller tells us, then you should absolutely be pursuing all benefits, CPP included, and of course the long-term disability insured. But there's a bit of a catch. Now look, the pros outweigh the cons, but the catch is this. Insurance companies are not dumb people. They have smart people who are drafting their policies, and the policies will always have a section in them that say, we're going to pay you X, usually about 2/3 of what you were making before you became unwell. But if you have an entitlement or an eligibility to get other sources of income, like CPP disability, we're going to take a credit for that. And that's the real kicker, right, John, is that it then means that someone is going to get less money, essentially, from the LTD insurer because the expectation is they're going to get the money from the government for CPP disability. They work separately, though, and that's the most important thing to keep in mind, is that you can make an application to the government for CPP, and that technically is independent from what's happening with your long-term disability claim, even if the LTD policy has that section, as I referenced, about getting that credit. But overall, if LTD ends, but you've got your CPP to rely on, at least you've got some money coming in. Absolutely. Gives us lots of opportunity to pursue the long-term disability insure. And by the same token, it's good leverage. It's the government saying, hey, you've got a severe and prolonged disability. I'm going to hang that over the insurance company and get a good result for these people.
Thank you for the phone call. We are out of time. Here is how you reach Tamar. Moving forward for the next show as well, 1-855-821-5900. Help@disabilityrights.ca through an email, and we'll catch you next time. Thank you so much for tuning in.